will be out here, order dated 23/12/22, passed by same code in Miss Case bracket NIA number 46/2022. Okay. Same thing. Out here, the earlier one, you take the case number, it will be in the report.
Highly applied.
Heard, Miss
You, Nanda. On behalf of SC Vishwas.
You, Nanda, appearing on behalf of Mr. S.C. Biswas, learned counsel for the appellant. This is an appeal against the impugned judgment and order dated 25/8/23, passed by the special judge, Chirang at Kajalgaon in special POXO case number 18 of 2019, convicting the appellant under section 6 of the POXO Act, POXO case number 16 of 2020, by which the appellant has been convicted under section 6, convicted under section 366 IPC and under section 6 of the IPC, POXO Act. Full stop. The case has arisen out of Bilasi Para PS case number 648/2020. Full stop. Admit the appeal, call for the LCR. The appellant shall, same thing, same thing. The appellant shall, then out here it will be Bilasi Para PS, okay? Police station will be Bilasi Para. Okay. Then out here, there is again 4 weeks time to Ms. Bibuyan to file WO, same thing as the earlier case. That's what, 4 weeks time granted to file complete. Item 4, you have received copy? No.
Paper book I've got it.
You have got,
Yes.
you have not received.
Lordship, I have verified the office note, Lordship, where it is stated that Lordship, they communicated to us, Lordship.
Okay, nice.
Please collect paper book.
Lordship,
Ahmed,
Lord,
it says here. As directly you are appointed as amicus, please collect the paper book from criminal appeal section. Full stop, right? Mr. A. Ahmed, learned amicus curiae, is directed to, is to collect the paper book from the criminal appeal section in terms of the notice dated 18/11/22, issued by the registrar bracket judicial. Full stop. Ms. S. Jahan, learned APP, submit that she has received the paper book. Full stop. Accordingly, leave this matter for hearing in usual course.
I've also have got my paper book. There is an IA pending.
Yes. You've got the paper book, madam?
Yes, no, Lord.
No? Is there any extra paper book this week? There is there, just a minute. Paper book has been furnished to B. Buyan. And, not received. Okay, you are for SC Biswas.
Yes, Lord.
Okay, you give it to her. Give it to her. Huh? Okay, Miss
You, Nanda.
U. Nanda,
Yes, sir.
appearing on Mr. SC Biswas, has been given a copy of the paper book in the court today. To stop. Miss L. Jahan, additional PP, submits that she has received a copy of the paper book. Accordingly, leave this matter for hearing in usual court.
As far as the I am yet to file my objection, perhaps I missed it.
You have filed it.
Oh,
You
I
have
filed it.
Item
Achha,
5, you have filed.
Okay.
Maybe, file it.
I'm-
You have filed it on 20th December 2022.
Lordship, yes. In fact,
Yes,
Pranali
so,
Bhuyan.
yes,
Yes.
on the IA.
No, Miss Maya has filed. Oh, not good. कोई बात कोई बात नहीं जैसे
Yes. What is your submission? You see, since the paper book has already been received by you, we can dispose of the entire thing. In the meantime, we will reject this IA. Okay, because we will listen for hearing. We'll listen for hearing. Right. Heard, Miss? You Nanda. You stands for
You full stop Urmilina.
Nanda. Okay, you Nanda, appearing on behalf of Mr. S.C. Biswas, learned counsel for the applicant slash appellant. Also heard B. Buyat, additional treatment.
Oh, not a single mark.
This IA has been filed for suspending the jail sentence awarded to the applicant by the impugned judgment dated 30/9/22, passed by the learned Sessions Judge Baksha, Mushalpur, in connection with Sessions Case number 117/2018, convicting the applicant under sections 302/326 IPC and sentencing him to undergo a rigorous imprisonment for life with a fine of rupees 1,000, in default, SI for 6 months. The yes, what will be a submission? I think there are no eyewitnesses.
There are
There
two, one injured eyewitness
are.
and there's a
PW?
oral PW5, madam.
Where is that?
Lordship, my objection, PW5 Binod Kumar is eyewitness.
No, what is your paper book, page 70?
Oh, Lordship,
Page 70.
yes, my lord. Informant is my uncle and accused Mohan Kumar is my own brother. This is Padma Kumari was my mother. So here, Lordship matricide, my lord, killing by his own son. The incident took place 6 years ago. The incident took place 8:30 p.m. At the relevant time, I was residing at a distance place from the house of the deceased. My mother came and informed my wife during my absence that she invited a meeting to separate the accused from them and also asked my wife to attend me in that meeting. On that date, at about 8:30 p.m., I went to the place of occurrence. I went to the residence of my mother. Prior to my arrival in the residence of my mother, a halla took place at the residence of my mother. At that time, I entered into the house of my mother. Then somebody caused injury upon my mother and also to me. I actually could not identify who would hear, Lordship, but I made this objection from this judgment, your Lordship. Upon my mother and me. On receiving injury, I lost my senses immediately. But there is an oral dying declaration.
So
my lord.
where is the
PW3.
He's not-
Yes,
he's not
yes.
eyewitness. He's
Yes,
not eyewitness.
from
He did not identify the.
I know. PW3, your Lordship. Yes.
Yes.
Informant is my paternal uncle. I know the accused person. I know this is Padma Kumari injured Binod Kumar. Binod Kumar is still alive. At the time of incident, I was in Guwahati. The incident took place in so in the evening hours on the day of incident. I met injured Padma Kumar and Binod Kumar GMCH. Other people also were present there. Injured Binod Kumar said that the accused person had hacked him and his mother. Oh, here only injured. Injured said Lordship that he could not identify. Lordship, may I see?
And Vinod Kumar is respond number 5, PW5.
PW5. Let us see, my lord, Hollowed or informant has given something. I don't find any material, your lordship. Let the entire matter be heard immediately after the reopening. We'll also go through it through the paper book.
But I think the appellant surrendered before the police station. At page 49,
Right.
para 47,
Lordship.
the court has observed. Surrender of the accused on the next day of occurrence in the police station and the recovery of the offending dog from the house of
Post
judge.
bench. But lordship, learned session judge, judgment said that the evidence of PW5 remain unchallenged.
But PW5 doesn't say anything.
Yes, my lord. So after, we have made the objection basing on the judgment because we didn't have the evidence at the time of preparing the
There's no
objection.
evidence.
There's no evidence as
Only
such.
thing is that why did the accused surrender?
Yes.
That's what- Thing was that the dog was seized from the house of the appellant on being led by him. Page para 45,
Right.
page 49.
Lordship, may I pray that the matter be taken up after some time?
Right?
Not after some time, after the vacation.
Huh?
After the vacation.
Let us finish at least one thing.
Okay, Lord.
The appeal, so we can do it later on. There is nothing out here, madam. I think,
To
well,
go through it once, my lord.
what, we are going through it together right now.
Yes. Some PW1, it will be started.
You can start.
Yes.
You have filed your written objection.
Lordship, the weapon of offense was recovered at the instance of the accused person. That is one of the circumstances. I think. But disclosure statement. I didn't find it.
There's no disclosure statement. How did the learned trial court say that it was discovered on the basis of the statement
My-
made by the appellant? Now the brother doesn't want to implicate him, it appears.
Yes.
But the brother was attacked, he's injured, but he's not blaming his brother.
Rather. Let us see what the IO says, minor.
Yeah. Let us see the Caesar
My lord,
from PW1.
lordship,
PW1 does not say anything.
he says,
He says what?
PW1, page 9. During investigation, police seized a sharp dowel with a half feet long wooden handle on being produced by the accused person.
But whereas he said that this is the weapon used for the crime.
No, nothing. This was taken in my.
And I'm quite sure in these villages, everyone will be having a dao.
My lord.
PW2 says that he does not know. I do not remember it now. I did not see from where the police brought the
Brought the
seized
seized
down.
down.
He also.
He says, three says, my lord, who says? During the time of investigation, police seized the dowel from Mohan's house.
No, you see, even PW1 in his cross-examination says, I did not see from where the police brought the seized down.
Yes. my-
Police said that recovered the down. I put my signature.
Yes,
So PW1 also doesn't say anything. PW2 also nothing.
nothing.
PW3 also, it says that PW3 is not relevant. He said injured Vinod Kumar said the accused person attacked him and his mother.
Let's see what to do on that one.
Isn't this for something that nothing? The part is house. Downwards.
Nothing.
It's being laid by the accused person, but from where it was it is not here. One is not of the case. It is good. With the foundation of.
Yes,
Let
madam.
us see the sketch map, my lord, the place of occurrence.
There's a worker.
Page 60,
Page 60.
my lord.
Yes.
A is the house of Sri Mohan Kumar.
Kumar is that A.
My lord.
A is Human Kumar.
So, lordship, the incident had taken place inside
that
the
house,
courthouse. Whether any explanation is given by Trivandrum in Trivandrum.
Nothing. In fact, we can dispose of the entire case.
So,
There's
I'm
nothing.
saying, my lord.
Will dispose of the entire.
Lordship, whether this injured eyewitness PW5 has
Ah.
stated anything before the IO, may I check?
Ah. But will that count? Will that
Let
be
us
of
see,
any help?
yes. I know.
Will that be of any help when it is not given in evidence before the trial court?
So whether it had come from the mouth of the IO, whether it was stated before him or not, my lord. Because your lordship, it's a family, it's not that
No,
the
I-
son, he is the son, injured eyewitness is the brother, and the victim is the father,
That's
the
so
mother.
we know outside court.
There might
but
be,
As per the evidence.
lordship,
we
but
have
there
kept-
might be two aspects.
Ah.
Sometimes, my lord, some family settlement, land dispute, it might be
Could
so,
be.
could be. And another
If
aspect is,
if it was a land dispute, I'm quite sure the brother would have pinpointed his brother. In clear.
oh, your
clear
lordship,
terms.
but if it has come up on evidence that the victim has called them to separate the accused person, it is
Okay,
there.
that
Some-
was the reason. But
Yes.
then who has killed whom? Who has
It's not
injured whom?
there.
There's nothing.
But two aspects, one may be some other discord may be there, and one other aspect is that
Look,
one family member will not falsely implicate the other family member.
so where's the implication? Where are they implicating each other? That is,
That's
you
true,
show
your
that.
lordship, whether at the relevant point of time when the occurrence has taken place, whether this PW5 has stated anything before the police.
Okay, let's see.
Yeah. You know,
And assuming he has stated before the police,
yes,
will that be admissible as evidence?
that is not. It's for the purpose of contradiction.
Fill in the deep blue sea. Take your pick.
But the learned trial court heavily relied on the evidence of PW5, but evidence
So
is.
evidence is
contrary,
nothing,
yes.
doesn't implicate
My
anybody.
lord.
Must be there, must be. there, that's the thing.
Lordship, as we have not received the paper book, can it be taken up tomorrow?
No, we're taking up now. We don't have
Lordship,
time.
may I
to-
read it in us? It's in
Yes,
us-
yes,
it's
please. do.
Statement of victim Binod Kumar. মোৰ নাম আৰু ঠিকনা ওপৰত লিখাৰ দৰে সত্য, মোৰ বয়স প্ৰায় 40 বছৰ মান হৈছে। ঘটনাৰ দিনা প্ৰায় সন্ধিয়া 7:30 মান বজাত মোৰ মা তেখেতৰ পুত্ৰ শ্ৰী মোহন কুমাৰৰ ঘৰলৈ গৈছিল আৰু কিবা কাৰণত বা কথাত কাজিয়া লাগে আৰু ঘৈণীয়েকৰ কথা মতে এখন দা লৈ মাক মূৰত ঘাপ মাৰি দিয়ে। মায়ে মোক কাটিলে মাৰিলে বুলি চিঞৰ বাখৰ কৰে আৰু লগে লগে মই দৌৰ মাৰি গৈ মাক বচাবলৈ যাওঁ, কিন্তু কোনো কথা নোহোৱাকৈ মোক শ্ৰী মোহন কুমাৰে এখন দাৰে মোকো ঘাপ মাৰি দিয়ে। ফলত মই কি হল গম নেপাওঁ। পাছত গাঁৱৰ মানুহে আহি আমাক চিকিৎসা কৰাবলৈ গাড়ীৰে কৰবালে নিয়া গম পাওঁ। মোক আৰু মাক শ্ৰী মোহন কুমাৰ পিতা চয়নচ লক্ষী বা মোৰ নিজা ভাতৃয়ে মোক আৰু মাক দাৰে ঘাপ মাৰি গুৰুতৰ জখম কৰে। লৰ্ডশ্বিপ, মূৰত ঘাপ মাৰি দিয়ে, এটা পোষ্টমৰ্টেম ৰিপৰ্ট।
Okay. No, I'm quite sure it is by sharp edge weapon, whatever.
Whether it's on.
But how do you connect
My lord.
the act with the? with the-
Yes, my lord.
You see, there is a 161 statement
My lord.
and there is a testimony recorded in the trial court. If it is at variance, now which one do you have to consider? The court can consider only
The thing which goes in
testimony
favor-
before the court, then what
which goes-
remains?
Yes, my lord. 65.
It's 65. What is that?
It's on telephone. Skull vertebrae paste on, it's written paste on. Page 67.
Page
and-
torn.
Yes, cut injury of left frontal region, extradural hemorrhage, left frontal region. So it tallies your lordship, whatever he has stated before the.
No, no, there is no doubt that she died because of
My
that.
lord,
But then who inflicted that
my lord.
blow? That is the thing. that sharp edge weapon,
My God.
whether the appellant has inflicted or not. Either it's very shoddy or either they want to help the investigating authorities want to help them or, I mean, it's everything is done very shoddy.
My God.
There's nothing. Okay, then Okay. Heard so and so, you Nanda, learned counsel for in the main appeal, huh? For for the appellant. Most have also heard Miss B. Buyan, learned APP. Hearing concluded. Judgment reserved. We heard your strenuous arguments and we are quite satisfied. Next time, madam, please read at least the basics of the case.
Lordship request for order.
But you should, but
Yes,
the
Lordship.
IA was there, 389 was there.
Lordship,
The
can it be
WO
taken
had
up
been
at
filed.
2 PM?
Hello, Purvo. Second.
Because we have reserved it. I think, don't worry too much.
So I.
You shouldn't worry.
Much obliged.
Ramzan Ali.
Paper book is ready.
Paper book is ready, but notice has to be that
Acha.
the victim has to be informed. Now, you are an amicus out here?
Lordship.
You are amicus. So
No,
this is a
no, they are not
JLP.
amicus.
Huh?
They are not amicus. Amicus. Oh, there were other advocates before. Now they have changed. Perhaps they are no longer there.
Received the paper book yet, Lordship.
No, you're not an amicus.
But then there, these are other advocates, sir.
Other,
Perhaps they did not appear and he was appointed as an amicus. This is not a jail appeal.
No, it says Mr. A. Ahmed Learned Counsel represents the appellant. How do you represent them? Have you been engaged by them? Then why do you come?
Lordship,
You
I on
cannot
behalf
come.
of A. Ahmed.
Huh?
I on behalf of A. Ahmed.
Oh, you are on behalf of Mr. A. Ahmed. Say that. That's what I'm saying.
Oh,
Why
A.
did you
Ahmed
say,
names,
when I asked you whether you are the amicus, why did you say yes?
A. Ahmed name is there. He has filed wakalat now.
Correct. But he's not the amicus.
No. Lordship, correct, Lordship.
Huh? Please be fair
Lordship.
to yourself also. You might bluff the court, but you're also bluffing yourself.
Lordship, in item
That
4,
is, you have got to be careful with that.
Lordship, item 4 is amicus. Lordship.
Huh?
Item 4, in item 4, he is amicus.
Item 4, you are the amicus.
There is some confusion.
There also, Mr. A. Ahmed is the amicus.
Lordship.
You are A. Ahmed,
No, Lordship.
then. Have you got the paper book?
No, Lordship.
No.
I've got it.
Acha, must be a copy is there. Give it to him.
As far as notice is concerned, let the same process be undertaken again. He'll give the copy. to
No, right. Right, Mr. A. Ahmed. No, Mr. What is your name?
Ayu Chaudhary.
I.U. Chowdhury. Appearing on behalf of Mr. A. Ahmed, learned counsel for the appellant, has been furnished a copy of the paper book in the court today. Full stop. Full stop. Ms. S. Jahan, learned APP submits that she has received a copy of the paper. Full stop. However, the records reveal that the victim / guardian of the victim have not been informed regarding the pendency of this case. Full stop. In that view of the matter, the appellant shall serve a scanned copy of the appeal before the registry of this court. And they shall transmit the same to the learned APP, Ms. S. Jahan. Full stop. Ms. S. Jahan shall thereafter forward the same to the officer in charge of the
Uriam Ghat.
Uram
District.
Ghat PS, URIAMGH80, Uriam Ghat PS Police Station, comma, as the case pertains to
And to
Uriam Ghat
PS case
PS
16.
case number
16
16/2020. The OC shall thereafter submit a report of service of the scanned copy of the appeal to the victim or the victim's guardian,
Here victim is the informant.
comma, who is the informant? Here the victim is the informant.
Lordship.
Yes, correct.
She is the informant.
Who is the informant?
Government
List the matter after 4 weeks
Howland.
in the order column.
I is there in my objection is on record.
Yes.
I for my lord bail,
Just give me the criminal appeal.
criminal appeal, my lord.
Oh, is it?
You have got the paper book?
Yes, ma'am, that is it.
Okay, in the, yeah, okay, now, okay. Now let us go to the IA.
Yes, ma'am.
Any eyewitness?
Yes.
My lord, two eyewitnesses, my lord, three are hearsay, my lord.
Three hearsay.
There, yes, my lord.
Which one is not hearsay?
My lord,
The son and the father.
son and the father,
PW,
lordship.
PW,
PWD three and my lord
Five.
PW five.
5.
three is the son,
Three is the son, five is the father, my lord. Or the
PW five is the father.
Father,
So they are both eyewitnesses.
they are divided. Yes.
And
And on,
any relation to the applicant?
no, my lord, they are
No.
not relation,
Their
but
children's fought.
Huh?
Their children fought on the earlier day over some water bottle.
1 week back,
So,
FIR filed by me, my lord. And also they, after filing of FIR, they filed a cross FIR. And they have some other also, my lord, problems are there, my lord. And only thing is that, my lord, they are before this in custody for more than, my lord, 1 year after passing the judgment and order, my lord. And my lord, before hearing, my lord, they may be released on bail.
No. Better not. It's difficult to put them in again.
And there are some
You see, that,
contradictions.
no. You see, prima facie, we have got to be satisfied only whether there's a prima facie case. And now there's a conviction already,
Yes, ma'am.
and there are eyewitnesses.
Yes.
dying declaration also.
Lying declaration not there.
Not there.
Not there.
So there are eyewitnesses. When there are eyewitnesses, now you'll have to maybe think of whether it comes within the exceptions or not, or some other. But even for that, you'll still have to be convicted
Yes, my lord.
under
There are-
a relevant
my lord,
provision.
What happened, my lord, the incident took place in broad daylight in the market. In mosque and madrasas are also there. There are shops. My lord, no independent witnesses were taken into consideration, my lord. Prosecution has not taken any.
Where
independent-
is the requirement of independent witnesses? This is a murder.
Yes, my
You are you going to tell someone, hey, there is
No, no,
going
my
to be a
lord.
murder, come, let's
The
go.
other
You are
witness- my
independent.
lord,
witness.
independent witnesses are present at the time of occurrence, my lord. They were not exactly, they are interested witnesses because some, my lord,
Interested witnesses are also witnesses unless you can
Yes.
show that the same prejudices you. What is wrong? Interested witnesses are also witnesses.
Natural,
Yes, madam, what?
they are the natural witness,
Who?
the relatives.
Ah,
Because I have a judgment where it is shown that independent witnesses, although they are there, are there in their spot, but then they don't like to get involved in these offences. So
But
they
there is
don't
a
come
case
and
where number
depose.
of people are there, my lord.
what to do? You see so many WhatsApp videos. Someone is lying on the road, people are still driving by.
Yes.
They don't,
They don't like to
They-
get involved.
they
in
don't want
this.
to be involved and they don't care also.
But prosecution could have, my lord, bring them in.
You can't bring everyone under the sun as a witness. You need only one person, you don't need 3 or 20. For the time being, I don't think you've got any case for 389.
8, 9.
We'll see at the time of hearing,
Okay.
whether you can, whether we can make out case after scrupulously going through the evidence. Right now, 3 and 5 eyewitnesses are there.
My lord, father is old man, my lord. He may,
How old?
he is, my lord, above 65 years. My lord.
Oh, no, still young.
Still, young, but they are very poor, my lord. One man.
Poor,
can be
but then he's deaf committed.
If one person can be released, my lord, he can look after the family, my lord. They're very poor.
We'll see at the time of hearing. We'll see. Not.
At least
not-
one person, my lord,
No.
was released, my lord.
Offense is grave, otherwise
Offense is
both of
grave,
them
it's-
have used
yes,
sharp
it is.
weapons.
You're killing a life. Supposing the person dead was your neighbor, who you know very well. I don't know if if you can, on sympathy, you can, sympathize with the accused.
Ultimately, they will face, my lord. One person, but the father may be released, my lord. Face, my lord. My humble
Heard.
prayer, my lord.
Humble prayer rejected. Heard Mr. J.M.A. Chowdhury, learned counsel for the applicant. Also heard Ms. El Jahan, additional people. This is an application under section 389 CRPC for suspension of the sentence awarded to the applicant pursuant to the impugned judgment dated 12/7/22 passed by the learned sessions judge, Karimganj in sessions case number 129/2016, by which the applicant has been convicted under section 20302. No, has been convicted under. No, I think there might be more.
Yes, my lord. 302,
67.
34.
34. Convicted as 302, 34, my lord.
Has been convicted under section
Please start.
302/34 IPC. Along with co-accused Nooruddin,
Lord.
Noor, Uddin.
Mother.
Nooruddin. The appellant and the co-accused have been sentenced to life imprisonment with a fine of rupees 30,000 each, in default, rigorous imprisonment for 1 year. Yes, sir. The learned counsel for the applicant submits that though they are eyewitnesses to the incident in question, the eyewitnesses are interested witnesses, in as much as they are related.
Lordship.
They are related
Relative.
they are
Family
related-
members.
Huh?
Family members.
in as much as they are the family members of the deceased.
Yes.
He accordingly submits that the evidence of interested witnesses would have to be taken with a grain of salt, as their only aim would be to ensure the incarceration of the applicant in jail. Anything else?
Some minor contradiction are there.
He also submits that there are minor contradictions in the testimonies of the prosecution witnesses.
Yes.
And as such,
As admitted by the prosecution.
as the same has been admitted by the prosecution, the trial against the applicant no, not the trial, the applicant. The prejudice was caused to the applicant during the trial. He also submits that because of the above facts, comma, the prosecution case was vitiated and accordingly, the sentence awarded to the applicant should be suspended and the applicant released on bail. Full stop. Next para. Ms. L. Jahan, learned APP, comma, on the other hand, submit that PW3 and PW5 are the eyewitnesses,
The son and father of the deceased.
are the eyewitnesses to the act of the applicant in while taking away the life of the deceased. So,
And I find the
She she submits that PW3 is the son of the deceased, comma, while PW5 is the father of the deceased.
And there are dying declarations also why he is saying that it's not there. It was stated before the wife and the
So
daughter,
she also submits that the dying declaration of the deceased before the
wife of the
wife
deceased,
of the deceased,
PW1
bracket PW1
and daughter,
and daughter of the deceased,
PW4.
PW4.
But the son say in his, my lord, statement that at that time father was not in a, he tried to say something, but that he was not in a position to say something.
No, wife
That-
said with very difficulty,
there,
he
my
said.
Son say,
They have seen you, Mr. Council, hitting the back of his head with a spade. They have seen you as in broad daylight. What more do you want? What more proof do you want in this world? You want a video recording of every crime that has taken place, then in broad daylight, they have seen it with their own eyes. Hitting, while they were walking, you hit him with a the back of the spade on his head. What more do you want? Yes. What have I said? What's up? She also submits that the applicant had hit the head of the deceased from behind with a spade. And due to the injury caused, comma, the deceased had expired. She accordingly submits that the bail should be rejected. That the application should be rejected. On considering the submissions made by the counsel for the parties. And without going too deep into the evidence adduced by the parties, comma, we are of the view that as there were eyewitnesses to the crime in question, comma. It would not be. The crime in question, comma, the application for suspension of sentence should not be, cannot be allowed at this stage. Full stop. Consequently, the application for bail, the prayer for bail is also rejected. The IA is accordingly disposed of. Any observations made today shall not be considered to be the final observations of this court at the time of hearing of them.
my lord, some early hearing.
Every hearing, you've been there for 1 month, 1 year only. You will take it up. When do you want? When do you want?
November last week, December first week, anything?
Yes, ma'am.
Okay. Well, in the main appeal, right? List the matter on, give a date. When do you want?
My lord, in the first week of December, my lord,
Give a date.
First week.
on 12th of December.
12 December for final hearing.
I'm like,
Finish. Huh, finished?
Yes.
Oh,
Lordship
then
has
I
a
could have
single
given the dictation to her.
bench. Lordship has a single bench.
Agreement won't take time. Okay.
The hearing of the. There were two hearing matters, I don't know.
Huh?
Two hearing matters.
9 and 10. I don't know if madam will be there. Huh? Yes, no, that hearing is after rising of the single bench.
Oh,
And I have got another division bench at 2,
oh, so many.
which seat.
We keep Lordship busy.
And anyway, so one in single bench now.
So glad.
Item 14.
Yes, sir. I have instructions not to press the review.
What is your name?
S comment.
Mr. S. Count, learned counsel for the review petitioners, submits that he has received instructions not to press the review petition and prays that he may be allowed to withdraw the same. Full stop. No, not to press the review petition. Full stop. He accordingly prays that he may be allowed to withdraw the application for leave to file the review petition.
Yes, sir.
Correct.
Leave.
Full stop. Who's appearing for the other side? Mr. S. S. Roy
For the government.
appears for the state respondents,
I'm for capital.
while Mr.
Elmo.
L. Mohan appears for the respondent number 12.
One and two.
One and two. One and two. Full stop. The prayer of Mr. S. Count is allowed. The application is dismissed as withdrawn.
May I please, your lordship, with the consent of other side, lordship, I beg.
Why do you want to withdraw it? One thing, why do you want to withdraw it?
The clients have instructed not to pursue.
Already settlement has been made, lords. Settlement.
Because there are judgments.
And there's also judgment, we also found a judgment of the Supreme Court also.
Supreme Court, our division bench also there. Anyway,
May I please, your lordship, with the consent of other side, lordship, I beg to mention item number 8.
Eight.
Come after vacation, lordship, because lordship, I could not appear for the.
no, wait,
Lordship,
no.
lordship, I
No,
could
no,
not
no.
appear for the.
I know, you wait.
May I please, your lordship, my lord, I beg to mention item number 9,
Yes,
that may kindly taken after vacation, I have taken consent from.
no, you ask, you tell me whether this case is infructuous or not.
One part-
You consider that aspect when your turn comes.
Yes.
May I please, your lordship, with the concern from others, I beg to mention item number 15, your lordship. for-
15.
My senior is not well, your lordship.
What is this matter about?
I have no idea, your lordship, I'm.
Just give me idea.
I am appearing for the applicant on behalf of Mr. S. K. Mathis, CGC.
Yes,
We filed a IA for praying for modification of the order dated 23/11/2021.
Correct.
Publication number 6603/2014.
Ah.
In this matter, lordship, all the petitioners are not entitled.
not entitled, that's what you're saying, yes.
Yes, sir.
Only a few of them are entitled.
Yes, lordship.
So why isn't it a review? Why modification?
My senior.
And
is-
why are you standing there? You're the review petition. I mean, you're the applicant.
I'm protected. My senior is on Lakes in court number 1.
Where is Mr. Saikia?
He's sick, your lordship.
He's sick.
Already 1 week he's not attending court.
What to do? Though this matter could have been thrashed out today.
Your
It's a
lordship,
very small matter.
we have taken already consent from the,
You're taking concern.
We have no objection, lordship.
Oh, you have no objection. I have objection. Haven't you received the notification of the High Court asking you to submit written applications for adjournment? Otherwise, you're wasting my time and everyone else's time also.
Lordship, my senior is on Lakes in court number 1. Let the matter come, my senior.
No, madam, you see, when you ask for adjournment, you should give prior warning to the judges. So that we don't have to read the file. We can devote our time to something else. Some other file. And if you were sick for the last 1 week, you had ample time yesterday to submit. I think, when will he, now it have to be after vacation only.
your lordship, any that can.
Next time, please, you see his case is that the order that we passed earlier will be, this court has made it applicable to all the petitioners. But he says that it will be applicable to only some of the petitioners, not to all. So if your senior cannot come on the next day, please find out whether his statement in the application is correct or not. That's all. It's a very small matter. Right. What is your name?
Elmar, your lordship.
Miss Elmar, appearing on behalf of Mr. I.H. Shakya. Mar will be H.M.A.R. Huh? Elmar, appearing on behalf of Mr. I.H. Shakya, learned counsel for the respondent. Prays for adjournment on the ground that Mr. I.H. Shakya is sick and that they have taken the consent of the learned counsel for the they have taken the consent of the learned CGC, Mr. S.K. Mehdi. The next para, the application is for modification of the order, judgment in order. No, where is the order? Is for the modification of the order dated 23/11/2021, passed in WPC 6603/2014. On the ground that no, not on the ground, wherein all the petitioners therein were to be given the revised pay scale with areas. Full stop. However, the applicant's case is that only some of the petitioners can be allowed to enjoy the benefits in terms of the order that is to be modified, and not all the writ petitions. List the matter after the vacation.
Wait, your lordship. Because non-payment of bill after requisition will be the subject issue in the matter.
Who is for the other side?
The government and the BTC will also.
Huh?
Government council and BTC will also. DGP and
Who?
government about some and
Government is huge. Which department?
Director General of Police and
Huh?
the police has been made a party.
SP, BTC.
And the
Yes,
director.
madam.
I'm appearing on behalf of Mr. Esper for BTC.
BTC. BTC also
BTC,
party.
BTC is number 3 only. Those are appearing for the police.
They will be appealing.
Yes, Mr. Roy, what is to be done?
Lordship has already passed an order phase 6
No, your claim is for 2014 area.
from 2000, but bill has been paid.
Let me
It's a
have the
continuous cause of action.
Huh?
Let me have the instructions. Lordship.
Because some bills have been paid, Millard, if your lordship sees the chart, Millard, and so they can verify and they can submit it, Millard, if they have,
Lordship, let me
they have
have the
dispute, Millard.
instructions. Otherwise,
Okay, right. Mr.
Ilal, Lord.
A. Lal, learned counsel for the petitioner submits that the hiring charges of the petitioner's vehicles amounting to rupees 69,06,437 have not been paid to the petitioner. He submits that the bills pertains to the period from 2014 onwards. Full stop. Mr. S.S. Roy, appearing for the respondents number 1, 2, and 4. Submits that he will obtain instructions with regard to the above. Miss J. Rajkumari appears on behalf of Mr. S. Bora, learned counsel for the respondent number 3. List the matter after the vacations to enable Mr. S. Roy to obtain instructions.
Lordship, they kindly fix a date.
extra,
Huh?
extra.
They kindly
copy
fix a date, Millard.
Even dates,
Lordship, extra copy.
extra copies. is given.
Then, I'm of that, Millard.
Lordship, non-payment of this petitioner's bill lordship for purchase of the diesel oil on credit by deputy commissioner.
Diesel oil.
Lordship, from the
Who has purchased diesel oil from you?
deputy commissioner.
Huh?
By the deputy commissioner.
Deputy Commissioner of,
Amin Gao,
I mean,
Kamrup. notices you should have obtained an instruction.
From which year?
2021 to 22.
Why don't you file a civil suit?
Lordship, the
Why don't you file a civil suit? It's within the 3-year period. Limitation doesn't bar you. You can file a section 80, you go to the civil suit. Why should we take up this? I can understand when you're time barred and then you need some help. But here you don't need any help. You've got the remedy available. Section 80 is there. You file a section 80 notice. Have you filed any representation here?
Lordship, the
Have you filed any representation here?
no,
it is
Lordship, because
repetition.
only bill has been submitted to Lordship. There is a countersign of the additional deputy commissioner, which has been acknowledged.
Mr. Please you file a representation. You cannot come directly to the High Court like that. When there is, first of all, when there is a section 80 CPC applicable.
Lordship,
You file a representation.
then I have to take instruction whether any representation was.
Huh?
I might have filed your Lordship. That
No,
is
no,
not
then I'm
record.
dismissing your case.
Lordship, I am taking time.
You
to-
go, no.
Lordship, for after vacation, your Lordship.
I heard Mr. L. Mohan, learned counsel for the petitioner, who submits that the petitioner is a dealer under the Shell India Markets Private Limited. He submits that the respondents have purchased. He submits that the respondents have purchased diesel oil from the petitioner's oil depot on credit since 2021 under the signature of the respondent number 5 for different vehicles which were used for the purpose of counter-insurgency operation as well as production of under trial prisoners before the learned court of the Chief Judicial Magistrate, Amingham. Though the petitioner has submitted his bills amounting to rupees 37,97,199.40. 37,97,199.40. No payment has been made. To the petition. Next, Mr. S.S. Roy appears for the state. For all for the state, first up. On perusing the writ petition, this court finds that the petitioner has approached this court directly without even submitting any representation
Lordship,
to the respondent authorities. First up. As such, besides the above, the petitioner has the efficacious alternative remedy with regard to his grievance by approaching the civil court. Yes,
Lordship, I will file additional affidavit with the effect of Lordship, but 1 week time may be granted to your Lordship.
and that was the matter. This court is not of the view that this writ petition, the writ petition should approach the proper forum.
Lordship, I will be allowed to withdraw, file a press with, along with accompanying petition.
Huh?
Presentation.
What?
I will be allowed to withdraw to file a press with appropriate document.
Writ petitions accordingly discussed. Next.
Lordship,
Well, your lordship earlier, my lord, FASTA, the listing orders, my lord. But here what happened, my lord? The railway has not
substitute orders, but in the portal, my lord, our name still appears, my lord. We filed several representations, but till now they have not removed it. If your lordship see, my lord,
They have only recommended, recommended the revocation.
yes,
I mean, recommended revoking the order banning you.
yes, your
But
lordship.
then no final decision has been taken by them.
No decision has been taken, but your lordship has passed so far these letters.
Yes.
are-
My lord, my issue notice that this is
No, no, why are you not taking a decision?
lordship, it's a letter of 25/8/20. I have to obtain instruction of
25/8/23, 2 months back.
lordship.
How much months do you need?
So prior to that also we have submitted, my lord.
And it is a communication from the NF Railway Authority to the Railway Board, lordship.
Whatever.
So lordship may give some time, I will obtain instruction, or lordship may issue short notice, I will reply, lordship.
Or we can dispose of this writ petition with a direction to the concerned authority to take a final decision within a specified time
That
on the
also,
basis of this letter.
that also do on the basis of the page to 88, lordship.
86.
86. Even lordship, the another latest communication is also with me, lordship. It was on 21/9/20, lordship. It was written to the Railway Board, lordship. Lordship may indicate that letter also.
Give him a copy.
Lordship, lordship. It is reiterated, the lordship 88. Yes. 88.
Same thing it has written.
Same thing, it is reiterated page 88. So,
Yes, but portal, my lord, they have not changed. Portal at least, my lord.
No, this is the thing is that the chief engineer NF Railway
Yes,
has written to the railway board.
yes.
and as per my lord, so
Uh,
also
we
the
are
railway board.
Conveying their recommendation to revoke that ban order.
And
The
as per,
problem is that the authority in Delhi has not taken a final decision.
But anyway, my lord, till as per your lordship direction, that the penny has been crossed.
Many have been quite.
Crossed.
Ah,
Your lordship has crossed that penny.
Page.
Page, my lord, 78 of your lordship judgment, my lord.
Yes.
That last para.
Yes.
12. In view of the regional structure, in viewing letters so and so issued by National 6, so far the petitioner is in blacklisted depart from participating in any future tender is ever set aside. So your lordship is only set aside, my lord. Only thing, my lord, they can take some decision if necessary. My lord.
The above is however subject to any final decision.
Yes,
So till they take a final decision,
Nothing has been
your department
Yes.
has been a banning the
That is set aside by your
has been
lordship.
set aside. So he has to be,
They have to modify the portal, my lord.
as per
Yeah.
my lord, so that the boards have to take decision. So lordship may dispose of on the basis of that two letters.
Why again, my
No,
lord?
no, they will take decision. But in the meantime, his company should not be stated to be a banned company.
Yes.
That ban will not be there.
As per lordship's observation in paragraph 12, lordship may that part of again reiterated, lordship.
I have to read it.
Lordship, lordship.
But in that case, why didn't you file a contempt?
Lordship, that is the issue.
My lord,
To file
because
contempt.
in the portal, my lord, that name appears, they have not taken any action, my lord, to change that.
So you file a contempt,
That is another aspect, but that
then
will not,
that would have been, that would have been more
my lord,
appropriate.
that will not help me, my lord.
Right.
That will not help me, my lord.
You'll make more
But I am a
enemies.
businessman, my lord.
Otherwise also
You
lordship.
you have got
does
to,
say
you have got to hit them also and smile with them also.
Otherwise, my lordship to reiterated the
So
same
they
direction.
may be directed, my lord, to change the portal, my lord, as part of the direction. Till any decision.
My lord may reiterated paragraph 12 as well as the letter. The two letters lordship may consider and dispose of the.
Yes.
Otherwise, lordship he has to prefer a contempt petition. The same cause of action.
But then his ultimate aim is to do business.
Lordship, we have no objection.
Why
Lordship
should he
may-
shoot himself in the foot? That's what he's scared of doing.
Lordship may reiterated the same, we have no.
Heard Mr. G. N. Sahewala, learned counsel for the petitioner, who submits that in terms of the order dated 11/5/2023, passed by this court in WPC 2168/2023. the blacklisting slash debarring of the petitioner from participating in any future tender pursuant to the impugned letters dated 29/10/2021 and 29/11/2021 had been set aside. Full stop. However, the same was subject to any final decision to be taken by the railway board in pursuance to the letter dated 17/3/2023 issued by the respondent number 3 and letter dated 13/4/2023 issued by the railway board. Full stop. He submits that as per the letter dated 17/3/2023 a clarification had been sought by the NF Railway. No,
No, my lord. This is
that,
a page
that the respondent had submitted.
page 69, my lord, that letter, 17.
No, just a minute. What have I said? Comma, which was in response to a clarification sought by the NF Railway, comma, the respondent number 3. No, the respondent number 11. Had admitted that the documents used in the tender on the basis of which the petitioner had been blacklisted from participating in any future tender, comma, were not connected with the petition. Instead of respondent number 11, you write, you have to write M/S Avi Jantrik Infratech Private Limited. Instead of respondent number 11. No? The letter dated on the other hand, comma. No, don't say it on the other hand. This is the letter dated 13/4/2023. Had been issued by the railway board, which was addressed to the Chief Administrative Officer, bracket CONS, full stop, bracket close, Northeast Frontier Railway, comma, asking him to clarify under what circumstances the NF Railway had taken a decision to reconsider revoking the blacklisting slash banning of business against the petition. and that the said letter had been made. No, first stop. The petitioner's counsel submit that the said letter had been made in pursuance to the letter dated 17/3/23 issued by the respondent number 9.
Now replied at page 86, my lord.
First stop. Next paragraph. Subsequent to the two letters mentioned above and the order dated 11/5/2023 passed in WPC 2168/2023. The respondent number 3 has written a letter dated.
No, respond number, my lord, the NF Railway has written reply. On 13/4, my lord, they have given that.
No, so this is
Yes,
by
number three, Lord.
the respondent number 3.
Three, Lord, three, Lord,
That's what I've said.
three, Lord, three.
Has written a letter, respondent number 3 has written a letter dated 25/8/2023, bracket annexure Roman 20 XX. That. Comma, which is addressed to the respondent number 7. Stating that as per the order passed by this court on 11/5/2023. In WPC 2168/2023, comma. A recommendation has been made to revoke the banning of business dealings with the petitioner. Next paragraph. So I'll make him submit this or you will submit this,
Lordship.
this letter? You, okay. The learned counsel for the petitioner submits that despite the order dated 11/5/2023 passed by this court, until a final decision is taken by the railway board with regard to whether the petitioner should be blacklisted / depart from participating in any future tender. Comma. The name of the petitioner should be deleted
From the portal.
from the railways portal. And also in the rights portal, RITES, not capital, RITES portal. Under the heading of banned / suspended / negative vendors.
Yes.
Next paragraph. Mr. Yes, Mr.
K. Gogoi, Lordship.
K. Gogoi.
K. Gogoi.
K. Gogoi.
K. Gogoi.
Here, CGC,
CGC, Lord.
Mr. K. Gogoi. Appearing on behalf of all the respondents,
Lordship, Lordship.
fairly submits that till a decision is taken by the railway board, comma, the petitioner's name, no, railway board, in compliance with the order dated 11/5/23 passed in WPC 2168/2023. The petitioner's name would have to be deleted from the Railways and Rights portal under the heading of banned/suspended/negative vendors. So sorry. Next paragraph. Mr. K. Gogoi also submits that subsequent to the letter dated 25/8/23 issued by the respondent number 3, comma, the respondent number 3 has again issued another letter dated 21/9/2023 to the respondent number 7, comma, in the same line as the earlier letter dated 25/8/2023. He submits that the present writ petition can be disposed of if a direction is issued to which respondent?
Respondent number 7.
To the respondent number 7,
As per Lordship's earlier direction, it should be respondent number 7.
to the respondent number 7, to take a final decision with regard to the question of to decide with regard to whether the petitioner should be blacklisted/suspended slash, no, should be, banned as blacklisted, comma, banned or suspended from doing any business with the respondent authorities. Proceed. Next. I have heard the learned counsels for the parties. Proceed. The operative portion of the order dated 11/5/2023 passed in WPC 2168/2023 is reproduced here and below. Now, comma, which is at para 12 is reproduced here and below. Huh? This is at page 78. A perusal of the above extract of the order shows that till a final decision shows that the blacklisting of the petitioner from doing any blacklisting/debarring the petition from doing any business dealings with the respondents while the letters dated 29/10/2021 and 29/11/2021 had been set aside. As such, it was incumbent on the part of the respondents to have deleted the name of the petitioner from the Railways portal and Rights portal under the heading banned/suspended/negative vendors. Comma, till a final decision was taken by the Railway Board in pursuance to the letters dated 17/3/2023 and 13/4/2023 issued by the respondent number 3, comma, which has been mentioned in the preceding paragraphs. Further, as can be seen from the letter dated 25/8/2023 and 21/9/2023 issued by the respondent number 3, comma, the respondent number 7 was to take a final decision after considering the two letters mentioned them first. Next, in view of the consent of the parties, no, in view of, no, just say in view of the consent, fine. In view of the, in view of the, in view of the order dated 11/5/2023 passed in WPC so and so. The respondents are directed to immediately delete the name of the petitioner from the railways portal and rights portal under the heading of banned/suspended/negative vendors. Full stop. The respondent number 7 shall also take a final decision with regard to the issue of whether the petitioner is to be banned, is to be blacklisted / debarred from future dealings by considering the letter dated 17/3/2023, 13/4/2023, 25/8/2023, and 21/9/2023 issued by the respondent number 3. First up. The writ petition is accordingly disposed of. Then you write, the letter dated 21/9/2023 issued by the respondent number 3 and which has been submitted by the learned CGC is made a part of the record and marked as an Exchange X.
Petition raises an issue concerning will of the power of the authority who can revise the items, the menus, and the price thereof in the catering cars of the express mail. Whether it is the railway board or whether it is the corporation who has the power to do that.
Railway board
Or this is called that corporation is IR Indian Railway. Indian Railway Catering and Tourism Corporation. It's an agent of the railway.
So what is this, what is the abbreviation of this?
IRCTC, I think. No,
IRCTC.
IRCTC, huh?
Yes.
So the question is whether, who can make the rates?
The revised, suppose they have these
Whether the rates can be revised.
rates with regard to the items or the meals supply, as well as the menu prescribed. Both issues are there. But here we are really concerned with the price. Who can do that? Is it the railway board or the corporation? But the basic issue is that.
So let them decide. So what is their problem?
Well,
So let them decide.
they can decide without your lordship's help. Because
Now, what is your grievance here?
yeah, our stand is
You've got a foot stop.
the railway board is the proper appropriate authority who can revise the license fee fixed.
License fee is different.
That is the license fee, part of that.
There is a license fee.
Yes. So it affects the license fee. So that is below the railway board issues these policies, as your lordships have done in some of those cases below. I moved one with
Long time back.
Yes. they are Milord, basically 2010 policy and subsequently 2017 policy. These settlements were took place under the 2010 policy. These policies are made by
Okay, these license fees under the 2010 policy.
yes,
So now there's the 2017 policy.
that is come, but this is covered by 2010 policy.
Ah.
And it is for the initial period is 5 years. And thereafter, if their performance is all right, they can renew the period for
For how much?
another 5 years, which has been done. This NIT in these cases was floated in 2014.
So now, okay, so now you have got to pay as per the 2017 policy.
No, that is not the case. It was because the proceeding NIT was issued under the 2010 policy.
When was it issued?
NIT was issued on 17/6/14. And all the 17 policy came in February 2017. Milord. So, and there is a clause in that policy also, clause 20, which says that if you have already completed your settlement under the 2010 policy and issued the letter of award before coming into force of the 2017 policy, the earlier policy will prevail. And that is, there is no dispute in this case because they have renewed the license. Initially, it was from 2014 to 19, and now it has been renewed to another 5 years to 2024. So there is no dispute on these. Only question is the prices of the goods have.
So the issue is not with regard to 2010 policy or
No,
17 policy.
no, that is not.
It's only the issue whether the prices. Now the prices were made by
The
who?
2010 policy also has a provision, Milord, that if you renew, then 10% increase will take place on the license fee. That is already there in the policy, and therefore they have increased that 10% added to it, and then we are paying that. There is no problem about it. Only thing is, when IRTC came into the picture, initially, Milord, they wrote a letter to the.
No, let us be one thing. Before going to that.
Yeah.
Now, when did you become a license holder of
Milord, the notice is, Milord,
17/6/14?
17/6/14.
Yes.
And then, Milord, we got the LOA, which is at page 67, date today. 37/14. And then, Milord, we
LO is only letter of acceptance. Where is the any agreement signed or anything?
No, that agreement comes later. It is the letter of award is the first thing.
Okay.
And
The
that is
letter of
what
acceptance or letter of award? What is this?
Yes, yes. They are asked to, they inform us that you are selected. This is the amount you have to deposit within a period of 15 days. or so.
So this LOA,
LOA,
A stands
letter of
for
award,
award.
letter of award. And once that is done, Milord, then
Now-
you get the license and then you start.
Now this LOA, when this is awarded, at what rate were you awarded? You were awarded on a particular rate.
Yes, Milord.
Now this rate was fixed by whom?
By the
Railway board. Railway board,
Yes, railway.
by the railway.
Because we offer, they invite bids, we offer highest bid gets it. And then, Milord, the question of license fee comes that they determine and they do it, and then the service comes, namely that this is the menu for these breakfast, lunch, dinner, you have to give these items, and this is the amount you will get for that. That is how it is. So we get that from the passengers, and which, Milord, helps us to meet the required payment to be made with our share of profit in that. That is
So
how
in
it
the
works.
rates, your profit is also
It's part
included.
of that. Because we have to. we have
So,
to
so
pay
2014 letter of award was given. So it is for 5 years.
5 years.
5 years means 2019 it
19.
expired. Then it was renewed
Again, you need to say, that is also there in the policy.
with
that
another 10%.
with
increase.
another 10%. Then, the IRTC comes into the picture. That is an interesting development. There is a letter. They say that the price of the meals, the inflation has taken place with regard to the price of the items, because the raw materials has increased, and you have not increased your
Meals.
rate of your bills. And therefore, it will be very difficult for these places to perform in the way they should perform. So they suggested a revised rates. There is a letter, my lord, page 270. And they wrote to the government that increase the price because the prices of raw materials have gone up, labor rates have gone up.
So what are you aggrieved? Why you
I'm
aggrieved?
not. Government, what has happened, Milord, IRTC itself was saying to the government that meanwhile the prices have gone up, labor rates have gone up, therefore their expenditure has gone up. Therefore, you should increase the license fee
Ah,
on the price of the bills and all that. So the the railways responded to that letter and did not accept the entirety of their proposal, but they increased, which is at page 274, Milord, their letter. 270 is the letter of IRTC to the railway, and 274 is the railway letter by which they increase the thing, not as suggested, but
increase the license fee,
like the meals belong,
fee, rates of meals.
rates of meals, and which has an impact on the license fee. So that also goes to show that it is not the IRTC who can determine the meals to be served and the items to be given. So this is something which they have to take approval of the central government to railway board to implement. Therefore, their proposal 270 was not fully accepted, but government on its own at page 274 has increased the
Rates of meals, basically rates of meals, that's
Yes.
what.
about the rate of the meals and also about the menu, how it should be. They have removed some items and increased the price, and that is how they approach that problem. Now, what is the development after that is what we are concerned with. The IRTC is now saying, for example, Milord, one vegetarian meal is, say, let us assume it was costing 50 rupees. After the government letter, it has become 80 rupees. There is a difference of 30 rupees. So IRTC is now trying to give a levy on these 30 rupees and calculating on their own and demanding from us the payment. And that is what we are challenging by saying that you don't have yourself that power. It was a compensatory increase on your own showing because of the price of the raw materials has gone up, the price of wages have increased, and all factors taken together, they have increased the prices.
So they want their share of it.
They want
They want a share of that increase.
30 rupees now.
They want a
They
share.
are trying to increase the license fee and making a demand.
Now, one thing, one question.
Yes,
On that 50 rupees, earlier 50 rupees.
Yeah.
Were they being given any share?
was there?
You see, prior to the increase in the rate.
Correct,
The rate was 50 rupees.
yes.
Now, was IRCTC
Huh.
being given
Huh.
any share of that 50 rupees?
Because that is an internal matter between, this is a government company, corporation. It's a
No,
instrument.
no,
of-
that's why I'm asking
No,
you.
it is
If,
part-
if it was not being given any part of the 50 rupees earlier rate,
because they will have their own income. That is, I am not
Ah.
concerned.
huh,
What I am concerned is who can determine that a stage has come that the meal has to be, rate of the meal should go up. Is it the government or the IRT?
no, but you've just said
Ah.
that the rate of the meal has gone up from 50 to 80
By,
by the railway board letter.
yes,
So then where,
it's a compensatory increase. Government thought
ah,
that the prices have gone up.
so where does IRCTC come in here?
No, they should not. They suggested a certain.
They gave a proposal, it was
Proposal,
acted
on
upon
the
partly,
basis of
whatever.
that,
Ah.
The government looked into the matter, even in their own 2010 policy, or lordships will find how, what factors they will take into account in determining all these
Yes,
rates.
yes,
So that is in short the question.
yes,
Who can do it?
yes.
You can, the corporation can certainly suggest to the government. It's
No,
part
so,
of the
so what do they want now? What does IRCTC want? What
They
does
are now saying that because the prices have gone up,
increased, yes?
you are earning more, therefore you. out
Give
of-
more
out of
license
this
fee.
30 rupees, they are taking an assessment and trying to.
Okay, so,
Make a demand.
so now earlier, on the 50 rupees, you might have been, how much were you paying the railway board or the government as license?
We pay, as per the bid.
Okay.
We have to pay because I am the highest bidder, I say. So I am accepted and they determine the installments by which I have to pay the railway board. And now the corporation will get that money.
So basically, your bid was calculated
Yes,
on the basis of that 50 rupees.
yes. They
So
take into
now,
account all that.
so now, what they are saying is that since the bid was on the basis of the 50 rupees earlier, and since now it is 80 rupees, you have to pay a proportionate amount
Yes.
on the 80 rupees, on
And
the
that-
extra
that-
30
that
rupees.
is a determination and demand by them.
But or you on the other hand say that the entire 30 rupees should come to you.
We don't know.
No,
I get that payment, but I have to return back by way of installment, which is determined by the government
on the basis of what?
on the basis of this health proceeds.
On the basis of
And
50 rupees or 80 rupees?
that is their concern, they will definitely, that format is also given in the policy as to what factors you will take into account in determining the rate of the meals. And what you will give in the meals, lunch, what are the items, what is the extent of the.
No, I'm still not getting it. So where does IRCTC come in?
IRCTC was constructed, it was conceived by the government, central government. It is a part of the central government, it's a corporation, public sector undertaking. What for? For streamlining the catering service in the rail. So their powers are what the central government will give them.
Correct.
If they have a power to suggest to the central government, which they have, that this is the situation, you increase. Central government may look into it, may agree with them, may not agree with them. The extent of increase also there may be difference, but it is the decision of the central government which will really govern,
Okay.
which has taken place here. So
So,
as I was giving, from 50 to 80. Now, suppose government wants to get more from me. Who will do? Is IRTC alone can just determine that, okay, you are getting earlier 50, it is now 30, 80 rupees, this 30 rupees. without even taking to, it's a compensatory increase. Why have they increased? Because the prices have gone up. It is your case to the government that increase the price, otherwise they can't give the service we want. So it's an interesting question. Lordship will have to examine that. And they will come with their version. So your Lordship can issue notice and quickly dispose, because this will involve a lot of implications for the both sides.
So what I asked this IRCTC,
Yeah.
they also provide some service.
Yes, yes, they run the show.
They run the entire show.
Because earlier.
So,
it was the road show.
their income is based, their income is made on the base of the
Yeah,
license fee.
Possibly, I don't know the
Probably,
internal
otherwise-
monetary arrangement. Possibly they get a portion of that. Because the central government, ultimately, the policies are fixed by the central government. And therefore, 2010 policy was there, then came 2017. So it is, they set the thing. What are the items will be there in the breakfast? What will be there in vegetarian meal?
Supposing the railway board gives a letter.
Yes.
Saying that the IRCTC.
Yes.
Will be the sole repository of power with regard to all these issues, then. Whether,
If they delegate that power, yes, they will be acting on as a delegate of the central government. They will take the approval before they announce.
then
the
you have got no say.
No say. But if they cannot produce that delegation or their approval for the enhancement they are proposing to, demanding from us, then because you are,
So basically, you're saying that every action to be taken by them has to have the seal of approval of the railway board.
that has to be there. That is our respectful submission. And those two letters I was referring to, 270 and 274.
Yeah.
Clearly indicates that
This 270 is letter dated?
yes, kindly see that page 270. This is a letter from IRCTC. 5719 at page 270.
Yes, yes.
Member Traffic, Ministry of Railways, Rail Bhavan, New Delhi. And Railway Catering and Tourism Corporation Limited, a Government of India enterprise, Mini Ratnam. At the top. And they are writing this letter. And giving,
Yes, I think basically, yes, Mr. What,
and
are you here in this case?
Yes, I'm there.
So you'll have to obtain instructions, I think, or
Well,
anything to say?
My lord, if you also see, my lord, that in 2017 policy,
Ah.
so far management of the catering minister are concerned, it
Ah.
is given to the IRCTC.
Okay, it'll be
There
given.
is a tripartite agreement between the petitioner,
yes, there are no.
and my lord,
dispute on
that
that.
you also find at page 223. 223. Even we can terminate the contract also, my lord.
No, that is all there. I'm not disputing all that. My
223.
dispute is with regard to the fixation of the price of the meals and the.
223, yes.
Yes, this is the my lord, agreement, railway, then IRCTC, and then this petitioner, my lord. And as per this agreement, my lord, everything is done, and the railway is getting, my lord, 40%. That will get that page 224, 8.5. We are getting 40%, my lord, railway, and we are getting 60% of the license fee. We have.
You are getting 60%,
Ah.
he's getting 40%.
No, railway board is
Railway is getting,
railway is getting 40%.
railway is getting 40.
Yes,
Railway is getting 40.
40, that is 8.5, clause 8.5. Same.
Page.
License fee shall 224. Shall be shared between NF Railway and IRCTC in the ratio of 40:60. That's right.
No, that is all right. That
My lord,
is their
so,
internal.
my
I
lord, there is
mean,
no difficulty at all, my lord. And he did the individual assessment, my lord, if your loss will see in the agreement at page 159. My lord, 159 in the agreement,
159.
my lord. 150, 154, I think. I'm just 154, my lord. So
Yes,
clause 8.3.
yes.
In the case of any division in catering tariff, the licensee shall be allowed to sell foods, meals at the revised rates to the passengers. In that event, license fee payable to the to railway shall be varied based on the reassessment of sale from the date of revision of the catering unit. So reassessment is being made, my lord. And reassessment, that letter is there that for reassessment. Reassessment has been done and thereafter the demand notice has been issued. Well, and there is an arbitration clause. If your loss will see page 212.
Yes.
Article 20,
into page.
that is dispute resolution, page 212. This is the, my lord, clause by which, my lord, arbitration is provided. In fact, my lord, the individual demand is there. In some of the parties, my lord, they approach the Delhi High Court under section 9. And there, my lord, the Delhi High Court, exercising power under section 11, appointed
Appointed
arbitrator also. Appointed arbitrator also. And pass some order there.
That
My lord,
is
till,
a- that is a different view.
my lord. Same, my lord, same letters has been, my lord. If your
No.
lordship wanted to see, my lord, I can give a copy of the same, my lord.
Anyway, you know,
Well,
that is arbitration clause does not prevent the.
Now, what
High Court
about,
from
what
going
about
to-
212?
My lord.
Page
Huh?
212?
This same letters has been, my lord, sent there. Same letters. If your lordship see, page 2.
The same at page 214, Milord, your lordships can have a look, 21.4. The agreement will be governed by and construed in accordance with the laws of the Republic of India, and the courts at Guwahati Zonal Railway Headquarters will have exclusive jurisdiction in all matters relating to this agreement. But apart from all this, Milord, there are Supreme Court judgments, as your lordships know, Milord. The jurisdiction of the High Court is not dependent on any agreement. It's a constitutionally given power to the High Court. And there are decisions that arbitration clause does not prevent the High Court from.
No, does not prevent, maybe, but
But this is a-
at the drop of a hat, we should not take it.
No, no, I quite see. It is not a question of whether it should be 30 or 40 rupees. It is a question is who has the power to.
No,
increase.
whether he has the power, IRCT has the power. The amount that you are going to pay is the same.
I am paying.
Then how does it matter to you
Passenger
whether
is paying,
who
not
gives the
I.
order? Huh?
Passenger is paying.
So how does it matter?
Ah.
Who is getting, who has passed the order? When you,
No,
when
no,
the
that
amount you
matters because legality of that question is involved.
no, but then how does, what is, where is your, what is law, what is the loss cost to you? The amount you're going to pay is the same.
No, if the government has not approved, it cannot be effective. That's the point I am making. Who has the power?
No. You see,
You see, your lordship will kindly see,
Hmm.
270 is the proposal given by IRTC
Hmm.
to the government.
Hmm.
They have not accepted that. They have said, in respect of certain items, we are withdrawing the delegation given to you. So it's not as if IRTC is the central government. It's a corporation. It has been given certain powers, and this power of revising a meal rate for the purpose of running the train is not given to the IRTC. That
No.
power is with the government.
Okay,
They can-
now,
they can offer a advice or proposal, but it is the government's ultimate decision.
okay, now, now the government decision is final now. So what is the impugned order or what is the impugned order that they have issued, which is
Page
not in, what is not in consonance with this
Look
government?
at Page 36. What they are doing. Because it is increased, these are compensatory increase as per their own document at page 270. And the page 36 is their demand now. Demand notice for revised license fee for post-sale assessment in lieu of CC 60/202019. In reference to the above, Deepak and Kung was awarded temporary license for provision for onboard catering services in train number so and so, so and so, so and so. Further, on issuance of instructions from CO IRTC, while letters under reference, EJ has calculated revised license fees on the basis of assessment of sales in post-paid SBD and non-SBD trains in lieu of CC 260 of 2019. Payable amount for train number so and so, we have 3 trains. First train, it is 58 lakhs 87 and 5517. What they have done is, they have taken the increase and then calculated the number. There was no assessment as such. RTI one, at least from 1 June, we have also indicated. And the assessment which has to be made is also provided under 2010 policy, where it says that you have to make the assessment in the lean period as well as in the heavy period and with periodicity. They come one day and make an assessment and then they make a demand. And the CD demands 58 lakhs, 25 lakhs and 20 lakhs, 1 crore something. Would I be approval of the central government? That's the whole problem. If I am right in saying that without the approval of the central government, you can't revise the rates, which is clear from the letter of their proposal at page 270 and government's reply on 274. Apart from the policy of 2010, where it is clearly said as to how you will.
Mr. Sahiwala,
Yes.
so basically whether the rates
Yes.
are to be prescribed by the railway board.
Yes.
Or the IRCTC, that's what.
No, as per the agreement now, this so far the enhancement is concerned, it's part of the agreement, 8.3 clause.
Enhancement, okay, but
Yes.
what about the revised license fee?
No, that is the matter of the, or the, if the rates of the foods is increased by the IRCTC.
Huh.
Because now IRCTC is governing everything. Now, here, my lord, they take help from the board. Here, what happens, if the foods rate is increased, proportionate increase in the license fee, that is clause 8.3 as per the agreement. 8.3 I have placed, my lord, that was page 154. 8.3. This is the agreement, my lord, of the petitioner, which is subject to arbitration.
All these will require some examination.
No, no, the only, now he's basically saying that the proportionate increase is required
Yes.
as per 8.3.
Yes.
If that be the case,
That is there, and his letter kindly see at page 270. What was his proposal? He has given a chart. What should be
no,
done?
no. Now the question is,
That government didn't agree.
okay, no,
Ah.
assuming now he wants a proportionate increase. If he wants a proportionate increase as per 8.3, the question is whether his proposal, his proportionate increase of the license fee is correct or not. According to you, is it correct or not? That is what question I'm putting. to you.
Who has done that is the question.
No, no, that is another
That is
question.
the crux of the matter.
That is only maybe going around the bush
No, it's not going around the bush.
because,
That is because if
no,
your
because
lordship-
this is agreement is here. There is
the
agreement.
agreement was there even when they wrote that letter of 270. they suggested the proposal for increase in a certain manner. 274 in the reply.
No, no,
Government
because,
said, no,
because this is only with regard to, you see, the license fee,
government has not given them the power to fix the rates.
no. You see, the
They can
license,
suggest.
let us see how the license fee is made, what is the parameters
Yes,
required.
my lord, your lordship, see page 31. My lord, we have made, directed to make assessment, individual assessments.
Let us see
That
31.
immediately your lordship will go to 2000.
Page 31.
Let me see 31, yeah.
Yes,
Look
we
at,
have written to general managers, it is my lord, these are parameters of assessment, because
Yes,
however, now, my lord, it has been decided by the competent authority that zone to
Where are you
undertake
reading?
assessment
Where
of
are you-
sales.
where are you reading?
Well, page
Okay,
31.
okay, yes.
that is.
Assessment of sales for the purpose of revision of license fee. Context mail so and so under parameters of the assessment. Then modalities of the assessment for the prepaid claims. Well, everything is there. As per this, my lord, they have made the assessment.
No, they have not done that anything.
This is
of
the
that.
letter which has been, my lord, do here. Now,
No, how do you, I want to know
Yeah.
the nitty gritty, basically. How do you calculate the license fee?
yes,
Say, for a 50 rupee meal,
yes.
how is the license fee calculated?
That is there, my lord, that page 34, my lord, after assessment,
34.
after assessment, my lord. If you'll also see the table, my lord,
No,
the new cell,
May,
per year.
may I intervene, my lord, a little to answer your lordship's question? Let us go one by one, you know. Page 58, go to the 2010 policy. This is what is all comprehensive, you know, 58.
Yes,
How
yes.
fixation of license fee.
Yes, let us go here.
Clause 18, fixation of license fee. Minimum license fees, minimum reserve price in case of tendered units shall be fixed realistically, equitably in order to have a fair, just and equitable fixation of license fee without adversely affecting the quality of service. It shall be based on the following factors. So the factors are given: category of station, type of license, number of organization. All these are the parameters because the relevant considerations which will go into fixing of the price of the license. All these are mentioned, Milan. The Zonal Railway shall evolve a formula based on the above parameters. It is the Zonal Railways for fixing the license fee for the units falling within their jurisdiction. A committee comprising 3 essay grade officers from commercial, finance, and civil engineering shall be nominated by the general manager, who shall fix the formula for each category of stations. The formula so fixed by the zonal railway shall be applicable to the entire zonal railway. Apart from the above, zonal railway may include and consider any other factor unique to the units. Minimum license fee will be fixed as 12% of the estimated annual sales turnover for static units, mobile units of ordinary mode, express trains, and premium superfast trains, and 15% for Rajdhani, Shatabdi trains, Duronto trains. These are special trains, because for them, 15% on the sales. For others, it is 12%. Of the annual sales turnover based on actual occupancy figures certified by the train superintendent. And at page 287, there is an RTI reply to for one Jhansi division that there was not even an assessment inspection. Anyway, now then, you know, this is the yardstick and this is the date which they have given. And 18.3, at the time of renewal of the license, license fee should be enhanced, reassessed based on actual sales turnover of the unit. License fee shall be reassessed and revised at the time of each renewal, subject to a minimum of 10% increase over the prevailing license fee of the unit. To arrive at a realistic figure, zonal railways will ensure that a fresh assessment of sales turnover revenue is conducted during the peak period and lean period. All this is provided below in the policy. That is, with periodicity of 3 3 months in order to assess the actual sales turnover so as to fix the revised license fee. Renewal will be done for the existing licenses only on withdrawal of court cases by the licenses, if any, against the railways and payment of this. So this is absolutely clear, Milord, in the policy, 18.3. And then Milord, kindly see 18.4. What the licensee will be paying is electricity and water, that apart. 18.5. Minimum license fee will be fixed by General Railways for all major units except food plazas, fast food units and food courts. GMUs at A, B, C category stations and
Okay,
SMUs.
okay, I think you obtain instructions, next date will decide.
Well, that can be, but here only, my lord, we have not touched the policy. We have only increased as per
Ah,
8.3, my lord. That if you also see that page 34, my lord, that sales, my lord, how far increased and
The
accordingly.
proportionate section.
The proportionate.
Let them
Not that-
file an affidavit and
You
produce
can file
the
it.
record what assessments they have made in the.
No, no, those will be different, those cannot be gone into by us.
No, whether they did it or not, it has to be gone into by your worship. It is provided.
Let it go to the arbitrator
No,
or to the
with
authority.
great
Why
respect
not?
without that.
Huh?
Arbitration is a different thing. If you have a dispute with regard to the.
Because we cannot go into the nitty gritty of
Yes.
all the figures.
My argument is very simple. And on the basis of their own two documents and these policy clauses. The parameters are given as to how the license fee will be fixed. And then what will be the rate of license fee increase at the time of renewal? That is fixed. You can't go beyond that. If you want to go beyond that, you have to take permission from the central government. That's about all.
My lord, we are not touching that part.
Your proposal,
Only,
that page
increase
27,
part. We have taken increase part.
your lordship
Nothing
will
more.
see the and
8.3
8.3, my lord,
page.
page 154.
that is different. See, one.
In case of any revision of catering tariff, the license shall have to allow to sell the foods, meals at a revised
In
rates.
this event, the license fee payable to railway shall be varied based on the reassessment of fee.
Yes, this reassessment of sale. If you also see, my lord, how we have assessed, my lord, page, my lord, if you also see there, page 134, page 34,
That is the impune order.
page 34.
You have not made
Reassessment,
any
after reassessment,
at
my lord,
all.
what has been done? The bottom, my lord, new sales per year. You also got it, my lord? Bottom, 18 crores so and so, whole sale per year was this much.
Yes.
Increase is this much, percentage of increase is 49.49%. Accordingly, my lord, annual license fee, it was there, my lord, we are not touching it. Only we are increasing it, revised annual license fee, E plus E into D percentage, my lord, nothing more than that. We have only touched it,
You have
as
not-
per that 8.3.
If he-
And
he
if there is
entered
any
30
dispute
rupees
regarding this, my lord,
Huh?
then the arbitrator has to decide if any dispute is there. So far, assessment is concerned. Assessment, how your lawsuit can see the assessment, my lord?
No, I am not talking of assessment. I am talking of your decision to increase, which is impugned. And the page 36 is the impugned order by which you are saying. And what they have done is they have taken this increase, which is a compensatory increase of 30 rupees, say in the illustration, from 50 to 80.
Who appoints these caterers?
My lord, now we are, my lord,
This is
we have, my lord, the renewal has been done by us, my lord, IRCTC. Because as per 2017 policy, it has been given to us. And now you'll also see that renewal has been given by us, my lord, at page 228. It is given by us. Because everything is
Renewal to him.
renewal, yes.
No,
This
no,
renewal has been
that is because
because that was
that
the,
is part of the 2010 policy. After 5 years, you will get a renewal of another 5 years. your enhancement will be 10%.
That is.
That is, I have shown your lordship. That is the clause 18.
No, but he said that the renewal has been done, not done by the railway board, but by the IRC.
That is dedicated to them. That is, I am not concerned.
Hmm.
Who does it? Because the corporation is created by the central government. It has delegated some
Who
function.
is for the railway board? Yeah. Have you delegated this, who is to revise the rates? Who has to assess, who has to make the rate assessment? With 43. 3.2, yes.
No, this is not the policy which is governing. I'm sorry. Huh? 2017, 2010, right?
For the standard, the railway board shall recommend.
But it do-
No, that is all right. For that has been done. Now with regard to the revised license fee, who is to do that?
You have kindly see, revised license fee, nobody can revise because it is fixed by the railway after bidding. And they say the renewal, you increase it by 10%. That is already covered by the policy
Ah.
clauses. I have shown you all. There is nothing beyond that. That is not the issue. The issue is 270 is their proposal. IRTC, kindly see that. They have given how much it should be done. Government of India didn't accept that. 274 is that increase. They have their own parameters of assessment. There are people have gathered together. It's not an easy job. And 287, we have given the RTI reply that in one zone, there was not even a assessment process.
Well, that's but that only we have increased. As approved by the.
No, that is an increase. That is a
They
compensatory
are
increase.
accepting the increase in
That
the
is the
rate,
whole
my lord.
problem, my lord.
Increase in the rate of the mill.
No,
They are not accepting the increase in the
no,
tariff, my lord, license fee as per clause 80.
the whole thing is absolutely misconceived. The prices have gone, it's a compensatory increase, which they have themselves suggested, but government has not accepted in full. So government has increased from say 50 to 80. What they are now trying to do is entire 30 without any breakup, as if it is a profit. They are saying themselves that prices have gone up, therefore it is compensatory increase. So the increase is a compensatory increase considering the increase of the material price of the material, labor cost and all that. And you can't impose entirely on 30 rupees without making a breakup. Your power to assess is governed by 2010 policy. It is on the basis of your sales. That if you don't do as per the requirement of the policy, it is invalid. And that is why, my lord, this entire chart, which was given by IRTC, was not accepted. Kindly see page 274. Revision in menu and tariff of catering service and Rajdhani Shatabdi standard meals of so-and-so, commercial circular so-and-so, so-and-so. A review of the menu and tariff of prepaid Rajdhani Shatabdi Duronto trains and standard meals and foods that are provided to passengers in mail and express trains on payment basis. So far the Shatabdi, Duronto and Rajdhani is concerned, the meal cost is included in the price of the ticket. Therefore, you are not bothered. So far, these other trains, we are dealing with express trains. They are not it is a different proposition. Therefore, this is set up by the board. Based on the above, the competent authority have decided the following. So this is by whom? Government of India, Ministry of Railways, Railway Board. That is their decision. Not the suggestion given at page 270. This is 274 after several months, 2019. A review of menu and tariff of prepaid Rajdhani so-and-so, 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 is decided by the board based on the above competent authority have decided the following. Instructions for so-and-so revised menu for Rajdhani and Shatabdi shall be as per enclosed annexure, page 1 to 7. Thus, the delegation given to IRTC, kindly see the language, delegation given to IRTC by Commercial Circular 10 of 29 for deciding the menu of catering services on Rajdhani Shatabdi Duronto train shall stand withdrawn from the date of notification of the circular. What more do you need for the purpose of saying that your word or your letter is not final? It is delegated. If you can show your delegate, you have given the delegated power of making an increase in the way you have done, the matter ends. Let them produce that document. It will be absurd without the approval of the government of India. The revised menu for Rajdhani, that is gone, withdrawn. Revised service price tariff for so and so are as under. So that is given for these three types of train. Then kindly turn to page 275. This is our mail express. 2.1 revised menu of standard breakfast and standard meals shall be as per enclosed annexure B 8 to 10. Further, it has been decided to introduce chicken curry as an option in standard non-vegetarian meal in addition to the existing standard non-veg meal with egg curry and standard veg meal. As such, there shall be three categories of standard meals: standard vegetarian meal, standard non-vegetarian meal with 2 eggs curry, and standard non-vegetarian meal with chicken curry. So kindly see the extent to which control is exercised so far as the central government is concerned. So it is not left to the IRTC at all. And then, Miller, the revised tariff of standard meal is as under. Now, how do you now determine your license fee? On the, your lordships will recall clause 18 of the policy on the basis of the sales. Produce your chart, we'll see what assessments you have made. 2 periods, lean and heavy periods, and with periodicity, it is not one visit.
Only one thing is that you see the reassessment of the
Yes,
the license fee
yes,
has to be based on the reassessment of the sale.
yes, my lord, yes.
So you let him see, let him see that. Who has to see? Can't he see that reassessment?
Yes, yes. He
Show him that.
Yes.
Show him that, and
Yes.
that's now. Once you produce that,
Yes.
I think if there is anything wrong with the reassessment, then that can be gone into by the arbitrator.
That is different.
Yes,
Your lordship is right.
only this is the thing, my lord.
Huh.
We are not touching the.
Kindly see at page
No, just
280
they show the reassessment. How is that?
No,
Yes.
kindly see below page 287.
Otherwise,
It's
no,
an
it's-
RTI reply from 1 June. Saying
no,
that
I
we
know,
have not
right.
done any reassessment.
Let them file. a
Right,
report.
Mr. Celso, there are senior counsel for the petitioner who submits that the
Impugned order.
impugned order dated 10/8/2023 issued by
There
the,
are three below.
huh?
There are three main thing is that 10/8/23. Otherwise below 8/4/22.
10/8/23,
And
8/4/20,
10/8/23, which is the final demand.
10/8/23,
8/4/22,
8/4/22,
8/2/23. And 10/8/23, page 36, which is the real demand.
no, so 10/8 is 2023, that is
Yes.
page 36. The next one, what page is it?
Page 31 is 8/4/23.
Acha, wait.
And page 34 is 8/3/23, 8/2/23.
So it will be first, submit that the letter dated 8/4/22, what is this?
It is all corrected
Well,
ultimately.
How assessment is to be made, my lord?
Yeah,
parameters of
ultimately,
assessment of
it
sale.
boils down to the final order 10/8/23 at page 36.
The assessment, my lord, this
That
one.
is the final fixation.
Who submits that the letters dated 8/4/22, comma 8/2/23 and 10/8/23,
Which is the final demand.
comma, which is the demand notice for revised license fee. Made on the revised rates for meals. Should be set aside. The basic grievance of the petitioner is that the revision of the license fee could only have been done by the railway board. By the railway board and not by the IRCTC. Oh, sorry. Oh, sorry. In support of his submission that only the railway board had the authority to make the revised license fee, comma, he takes the example. He relies upon the letter dated 5/7/2019 issued by the IRCTC to the Ministry of Railways, whereby a proposal had been sent for revision of the tariff in catering services. Full stop. And, not full stop, continue, and the letter dated 14/11/2019,
14/11.
14/11/2019 issued by the railway board. Wherein only a part of the proposal of the IRCTC had been agreed to. Full stop. Next paragraph. The learned council submits that as the a revision of rates for meals had been done by the railway board on the basis of the proposal made by the IRCTC, comma, the IRCTC could not have unilaterally revised the license fee on the basis of the revised rates for meals. Full stop. Next paragraph. Mr. J. Sahawala appearing for the IRCTC. Respondent number
2 to 4.
2 to
2
4.
to 5.
2 to 5. 2 to 5. Submits
2,
that
3.
3 to 5, my lord, sorry.
3 to 5.
Three.
154.
Submits that in terms of the master license agreement executed between the railways and the licensee, comma, in case of any revision in catering tariff, comma, wherein the licensee has been allowed to sell his meals at the revised rates to passengers, comma. The license fee payable to the railway shall be varied based on the reassessment of sale from the date of revision of the catering tariff. Full stop. He submits that the petitioner, the IRCTC and the railways have entered into a tripartite agreement. Where is that?
Page 223.
Dated 6/10/2017. Which is the provision?
Well,
Any relevant provision here?
no, even, well,
Wherein,
my lord, even we can terminate everything while terms and conditions. of that.
wherein the same the same shows that the act of wherein the same shows that the IRCTC,
Clause 8. man.
Huh?
Clause 8. that page.
IRCTC has been delegated the power to revise the license fee by the railway board. Correct? By the Indian Railways, by the Indian Railways.
Revise, not, my lord, here, clause, my lord, as per the clause, my lord, you can also see,
Ah,
uh, clause 8.
Ah.
CCM, TA, catering, and railway acting through other authorities hereby assigns the rights and liabilities as licensor to the IRCTC.
correct.
Acting through so and so.
so that's why-
IRCTC can do it.
That's what I'm saying. What have I said? In terms of clause 8 of the agreement. Further, as the license fee is to be shared between the NF Railway and the IRCTC in the ratio of 40:60, 40:60.
Yes.
From the date of handing over, from the date of delegating the duties of the railway board to the IRCTC. comma. There's no infirmity with the impugned orders passed by the IRCTC. Anything else?
As per clause 8.3, my lord.
Where is that page?
Oh,
One
your
to
lordship
two.
is already written.
What about that arbitration?
Yes, arbitration is, my lord, that's page 212. Clause 20.
He also submits that in terms of
Article 20.
Article 20 of the, what is this?
Agreement.
Of the agreement executed between the railways and the petitioner
Yes.
on 10/4/2017. comma. The dispute between the parties should be referred to arbitration. Next panel. Mr. H. Gupta appearing for the respondents number 1 and 2. Submits that what?
Policy. 2017. Since the entire catering business has been assigned to IRCTC, IRCTC has power to do that.
Submits that in terms of the new catering policy of 2017. The entire
Catering
catering business.
has been handed over to IRCTC.
That is all right. Handing over is all right. Yeah.
What was
Otherwise,
that?
be careful on your submissions. You have to file an affidavit.
The entire catering business of the Indian Railways has been handed over to the IRCTC by the Indian Railways. That's all?
Yes.
Stop. Next. The documents on record show that the revised license fee would have to be made on the basis of a fresh sales assessment
Clause 18.
subsequent to the revision of the rates of meals in terms of the letter dated 14/11/2019 issued by the Indian Railways. 14/11/2019, you write bracket page 274. So you produce that reassessment? Can you
They can
produce?
file a reply on both sides.
And in similar matter, my lord, virtually they have approached the section 9.
No, that we have not gone. What are you talking?
Yes,
The
no.
assessment is to be seen only.
Yes,
No.
yes,
If
yes,
any
sure,
dispute
you see, only thing is that you show him the assessment. Now, if he doesn't agree with the assessment,
Then I
then he
can,
can go.
yes, that is
He-
different.
Whether there's an assessment or not, that is all.
That is. And
That- that-
and whether the revision has the approval of your,
That
That's
is by agreement.
That is a
That's the-
different issue.
that is.
That
your
is, that is a
argument.
different, that is, that is your, that will decide.
Ah,
That issue will decide. But the question is, yes, you can look in that aspect also, whether that has been approved or not. That is of course different issue, which we will decide. But right now, where is the reassessment? If you can produce that,
Let them file an affidavit and say all that, because it's an important.
no, it might be a thick document. I don't know
Yes,
how.
I don't mind.
Thin document, I don't know, 1 page document, 20 page, I don't
Well,
know.
that-
So let him, right, so whatever I said.
Page 287, we have said that there was no assessment at all.
No, anyway, huh? Yeah, he wants to hold on to his money a little bit longer.
my lord.
No, your lordship will see, you can't tax me on 30 rupees, it's compensatory.
Whatever I said.
It's their own case, how can you take a case? License will not be affected.
Okay, list the matter on,
Well, it may be, it may be on 8.
list the matter on 8th, on the said date. huh? Mr. Yes, I will also produce the reassessment made by the IRCTC on the basis of which the revised license fee had been, the demand for the revised license fee had been made. You just put one thing. And the learned counsel for the petitioner has also submitted that as there was a revision of rates of the meals, the difference in the rates of the meals could not be taxed by the IRCTC as the same was compensatory in nature due to inflation. Correct?
Yes. Their own suggestion was that you increase.
Much.
Well, the status quo will continue till then.
My lord,
No, nothing will, you will see on the next.
No, they may start demanding, you know.
No, how, don't do anything till eight. Mr.
That
Sahiwala,
should be there on
don't do
record.
anything till eight.
Milord, that should be there on record, otherwise, Milord, memory.
Just like Mr. J.S. Sahiwala says, that no action, no coercive action will be taken
That's all,
to the petitioner till the next date,
yes. Next date is your lordship has fixed.
8 November.
Oh. Keep level.
Might be the lordship. This case is relating to my lord payment of subsidy. The petitioner earlier also my lord approached this honorable court. If your lordship can we see my lord in pursuance to an government policy my lord scheme, they have applied for subsidy. Page 42,
This
Yes,
page,
what it
this
is.
serial number 5.
item number 5.
Yes. Yes,
What happened my lord actually
So there is
recommended
no
amount.
impugn order here, Lordship. There is no copy of the SLC. Nothing has been annexed here, Lordship. I don't know how CS filed this. I mean, there was a
Recommended-
recommendation earlier. On the basis of that, certain
could not get it,
payments have been made. But the SLC order is not there. Only a statement has been made, nothing.
My lord, that copy they have not received my lord.
Then how can it come in?
have you asked
But,
for it,
Here,
madam?
my lord, your lordship will see that
Ah.
there's some recommended amount. The honorable court has passed an order.
This is, wait, are you here in this case?
Hmm.
In this page, in annexure 8, is the petitioner here?
Yes, yes.
Where?
At this,
Where is the petitioner? Bernice
Yes,
Braces?
Barney is my
Tea
lord,
Estate.
at page 64, I think. Page 67, my lord.
Bernice Brace, huh? Madam, where is your representation to them?
The
On the ba-
representation, my
On the
lord,
basis of this, you see, you cannot come just like this. There is a order passed by this court
Yes, my lord.
that the SFC will revisit and reconsider the terms, the claims of the petitioner.
Yes,
Now, please file a representation to them and ask them as to what has happened to your case, at least. You cannot come direct, we are not a
Thereafter, my
post
lord,
office.
They have paid in their account.
Yeah,
Now,
pay-
pretty happened. And
Huh?
certain amount they have paid in
The lordship, it
deposited in their
seems-
account.
It seems certain amount has been paid,
yes,
Paid on
but
their
there is
account.
no document how much money has been paid, whether what decision SLC has.
how much
taken,
has been paid to
nothing.
your account?
17 lakhs, my lord. 17 lakhs, 28,000.
17 lakhs, 28,000.
28,000. That's it in my paragraph one.
And how much are you supposed to receive?
19 lakhs, 31,000.
That is balance.
Balance amount,
19 lakhs,
31,000.
this is the balance amount that you have to be
Yes,
paid.
my lord, they have not paid. Only the thing, yes.
You file a representation and you dispose it off. Otherwise, like this, so this is
My
nothing.
lord, what happened, my lord, the SLC, my lord, they keep on changing. It is not a fixed body. So, my lord, there is no question of making a party. Because my lord, SLC for certain.
No, madam, you see. But on the date that they took a decision on your case,
Yes, my lord.
there would have been one.
They could not find it, my
Huh?
lord. They could not find it in the, my lord, online process. It comes in online. But
Madam,
they
where
could
is
not
your
find it.
representation? Where is your representation? No representation.
Representation, since they have earlier approached this court, my lord. So, my lord, they
Sorry.
have not filed any.
No,
representation.
you know very well.
So, let it come after vacation, my lord.
No.
Instead of praying, my lord.
No, not like
Others
this.
have trouble,
can-
my lord,
You
already.
can-
I have faced lot of trouble here, my lord.
No, you see, madam, what we'll do is, we will direct that you file a representation. We'll give you the liberty to file representation and we'll tell them to answer.
And then
You will tell them to answer your representation
thereafter.
and thereafter if you are, then you can come here. Otherwise, this is
Again, should
divided.
keep pending or my
No,
lord,
no,
can
we'll close
dispose of?
this. We'll close this because we'll have to have a fresh thing.
They will not do nothing, my lord.
Huh?
Another case, they will do nothing, my lord. Because both these are same parts of the
Madam,
same
at
thing.
least file a representation. You
Before
cannot,
the commissioner.
before whoever the authority is.
Authorities, my lord, time to time, the bodies changing, my lord.
So what? What can we
SLC
do?
is SLC, lordship, whoever is the party, there is a
Yes,
difference.
SLC.
SLC.
SLC, there'll be a chairman. Who is the chairman? The chief secretary.
Yeah,
Additional chief secretary.
Additional
additional
chief-
secretary.
So we direct the additional chief secretary.
They also keep changing, my lord.
What to do, madam?
Because-
But you have to do your part also.
Few days back, my
This
lord,
is-
I filed on contempt.
Ah.
After 10 days, he has been, my lord, transferred. Again, I have made another part.
Does not matter.
So, my lord, I
But
have to divide-
you see, contempt is
representation.
different, madam. Contempt is against the individual.
Yes, my lord.
This is against the body. Body might be anybody. But the body, body will be the same. Only the persons inside will change. All right. Heard Miss N. Saike, learned counsel for the petitioner who submits that the petitioner T estate along with other tea estate companies had filed various writ petitions with regard to the rejection of their prayer for grant of central capital investment subsidy under the Northeast Industrial Promotion Policy dash 2007 bracket NEIPP dash 2007 closed, floated by the central government. The petitioner's case was registered as WPC 1711/2019. WPC 1711/2019 was disposed of along with other cases, the leading case being WPC 5497/2020.
Page 70 of the judgment, my lord. Specifically, the central government has given, their number, case number is there, to release the subsidy. Page 70, paragraph, my lord, third. Under say to the government of India, Minister of Commerce and Industries.
Okay,
Some is
What have I said?
inspection have been issued by the central government to reconsider and including the petitioner's case, 3 cases, including the petitioner's case.
just a minute.
Thereafter also they are paid.
2020. Wide order dated 23/6/2022. By directing the state level committee headed by the Commissioner Secretary Industries and Commerce Department, Government of Assam, to revisit/reconsider the claims of the petitioners objectively and take appropriate decisions in accordance with the policy objectives. First up. In the said order dated 23/6/22, this court had also observed as follows. Page 70. It will start from Mr. Kalita, Learned Standing Counsel. And I'll just read it out. Industries and Commerce Department Assam has responded to the said submission by producing a copy of the written communication dated so-and-so issued by the Under Secretary so-and-so and submit that instructions have been received by the central government to reconsider the claims made by 3 of the writ petitioners with so-and-so, so-and-so, so-and-so. The cases will now be considered afresh in the next meeting of the SSC. We put this down.
Their case number is specifically.
I know, that's why I
Government of India,
put
yes.
stop. Next para. The petitioners counsel submits that in pursuance to the order dated 23/6/2022 passed in WPC 5497/2020, comma. The petitioner's case was reconsidered by the SLC and subsequently subsequently rupees 17,28,000 was deposited in the
Their account.
petitioner's account. Full stop. However, the balance amount of rupees 19,31,000 has not been deposited till date. Full stop. Okay, I've got one meeting. So, I'll just pass the order,
Yes.
dispose it off. You file a representation. That representation will be considered by whom?
By the
Legislature.
additional chief secretary or commissioner, commissioner can also.
Commissioner or party,
Commissioner also.
commissioner, by the addition of chief secretary, by the number two, huh? By number two. By the number two, because he's the Industries and Commerce Department.
Yes.
Okay,
Commissioner of Industry and Commerce can do it also. Number one can do it also. Commissioner of Industry. and-
okay, number one.
Number-
Number one and two,
1 and 2.
one and two, I think, one and two, huh? They will reconsider and with regard to the petitioner's claim for that money. And
And
give a reply in writing. Without, to be
after filing, they
communicated.
will be disposed of
within a month.
Within a month.
That I'll finish it up later.
Obliged.
Item number 30 after 4 weeks.
No, I will not, I'll be sitting. I have got a division bench at 2 o'clock. That will not take more than 10 minutes.
Item number
After 10, I will be sitting again. Don't worry.
Item number 30 is circulated for adjournment.
Yeah.
It will be after 4 weeks.
Item 13.
Yes, Lord. It's a review petition, Lord.
Okay, after item 13, on the prayer made on behalf of,
Of the respondent.
who is the respondent?
Worship here.
What's his name?
And the.
M. Das, learned counsel for the respondent, which is not objected to by the other side. This is the matter of the court.
My name as respondent number 3 may kindly be.
In which case? Acha, just put their names, huh? Mr. So and Kalita for respondent number so. Just take them, just give them a name.
Obliged.
And your basis for working their goals.
It was withdrawn as because of the new policy has come into force, but there is a clause for transfer of license, my lord. And kindly see the policy, my lord.
Okay, anyway, since you have asked for adjournment, we'll adjourn it. For some time, we'll give you breathing space
Yes, my lord.
for the time being.
Let me enter the pulla also.
Huh?
Let me enter the pulla also, my lord.
After that, you'll be ready. First up on the prayer of Mr. S. Lord Thakur, then Thakur for the petitioner. This is the matter after the pujas. After the vacation. So nice.
May I please your lordship?
Has it become infructuous?
One part remains still survive lordship.
What remains?
Or the period is over
It is over.
by another letter directing me to deposit the interest on MMDR. But they are not entitled MMDR lordship because all other amount I have paid. Recently, they asked me to pay the MMDR that is required. Earlier, at never point of time asked me to MMDR amount is required. I am ready to deposit the MMDR, but interest loan against the MMDR lordship, that is pays 53 lordships and pay 64 lordship will find, 63 lordships. 63,
They are challenging what letter? Letter
I am
dated?
challenging the letter dated lordship 8/3/2021 and 26/4/2021. Page 63 and page 52.
Because you could not work or what? Because the
None of us-
environmental
Yes.
clearance certificate had expired.
Yes, lordship. But in terms of this order of fiscal court, the responsible authority allowed me And I have done the period already in the over lordship, I deposited required money. But in respect to earlier period, they asked me to pay the interest on MMDR. They are not entitled. Recently, they asked me to, that amount is required. From the date I am ready to deposit that amount.
You are
interest-
ready to deposit the amount,
That
but not
amount,
the
but
interest.
interest not entitled. Lordship.
Lordship, that I'll have to clarify from the department if we can waive off the interest.
So you think it's accepted?
Yes, sir.
Okay, right. Mr.
I
If you-
bought her good
I Thakur, Leonard Council appearing for the
forest department.
Forest Department. Submits that. No, before that, you write, Mr.
F.U. Borbuya.
F.U. Barbuya submits that the petitioner is willing to deposit.
The
I
MMDR
deposited.
Yes,
Yes, submit that he has deposited the entire quarter KISS money.
Yes.
Required to be paid by him in terms of the letter dated 8/3/2021 and speaking order dated 26/4/2021. Full stop. However, where is the interest? Where is the letter?
interest lordship pays 64 lordship. Interest stated on MMDR.
Lordship, on every entry at 0.2 interest money is there.
They asked me on that date, lordship, how they. That MMDR is required from that point of time, they asked me. But they stated period to earlier point of time.
However, the petitioner is not willing to pay the interest in terms of the letter dated 8/4/2021. As the respondents are not entitled to the same. Mr.
I bought her.
R.Y. Botaku, Leonard Counsel for the Forest Department, submits that he will obtain instructions as to whether the Forest Department is willing to waive the interest on the KISS money. List the matter on.
After,
Huh?
after puja.
Puja, after the vacation.
In this matter, the affidavit was vetted and sent for signature to the district and section just Karbi Anglong. But the judge is, out of station, that's why signature could not be obtained. I will take up after the vacation. In the meantime, I'll be able to file the affidavit.
Okay. Mr.
HK Das, madam.
His name is not here.
No,
I am for respondent number 1.
I'm appearing for respondent number. I'm just placing
I am for 1.
Mr. H.K. Das appearing for the
3 and 4, my lord.
respondents number 3 and 4 submits that
2, 3
affidavit.
and 4, my lord. I'm
2,
sorry.
3 and 4 submits that affidavit in opposition has been sent for obtaining the signature of the deponent. He accordingly prays for 3 weeks' time to file the same.
My lord.
Prayer granted, list the matter after 3 weeks.
Keep your my lord. File. Wait, please, your lordship. Lordship, this review petition has become infructuous, lordship.
Yes, okay, right. Mr.
P N Sharma, lordship.
Mr. N. Sharma,
P N Sharma.
your name is not here.
In the review petition, I am the standing counsel, education department, lordship.
Okay,
This is preferred by the
Mr.
P N Sharma.
T. N. Sharma, P. N. Sharma, standing counsel for the education department submits that the matter has become infructuous.
Lordship.
Accordingly, he wants to withdraw the review petition.
Maybe close, lordship.
Okay, the review. Pusta. In view of the prayer made by Mr. P. N. Sharma, the review petition stands closed as withdrawn. Stands closed on withdrawal. Okay. Yes.
I am paying for the respondent. This is just to payment of gratuity matter. What's it?
order is at is.
Yeah, what to do? No one appears.
What should we take up after petition?
No one appears for the review petition. Mr.
A.K. Gupta for respondent.
A.K.
Gupta,
Gupta appears on behalf of
respondent, sole respondent.
the sole respondent. This court, in its order dated 6/4/2022, passed in WPC 6258/2019, had directed the respondents to pay the gratuity amount of 11,69,825 to the writ petition. The review petitioners have, however, taken the stand that only rupees 7 lakhs can be paid to an employee as gratuity, as the said amount has been fixed by the board of directors, correct? By the board. Board of directors of the corporation. What is your stand to that? They have
The review petition is still. That is the stand, my lord, because the writ petition was disposed of as the council at that time has admitted that this.
no, but you see, consent beyond the rules cannot be allowed.
No.
Beyond the rules that guidelines that they are following cannot be allowed.
My lord, as per the guidelines, this amount 11 lakh is some that order.
But there is a board
Yes, ma'am.
resolution which is in
My
force.
lord, board says that, my lord, since there is a financial problems, my lord, due to financial, so
Okay.
that's why they are not able to. pay.
Okay, right. As no one appears for the review petition, this is the matter after the petition.
Okay.
Finish. So you think this is the judgment slip. So, Mr. Roy, why have I suddenly got this single bench today? This is Barwa's, this is Barwa's bench. This is Budar Barwa? No. Anyway.